The stranger who bought my father's suitcase for $18 returned it 3 days later and told me the $2 million had disappeared from it. He said this quietly, standing on my front porch in the rain, with the old brown case held against his chest as if it were something fragile. I had never seen him before. He was in his late 60s, with silver hair, careful hands, and the apologetic expression of a man delivering news that did not belong to him. "Mrs. Bennett," he said, "I think someone in your family expected this suitcase to be destroyed." Then he opened it. The blue silk lining had been lifted from the bottom, exposing a shallow hidden compartment. Inside was a brass bank key, a photograph of my father standing beside a woman I didn't recognize, and a handwritten inventory showing a trust balance of $2,083,407. The money itself was gone. At the bottom of the page, in my father's unmistakable block handwriting, were 8 words. "If I die, Lena must reconcile every account." My father had been dead for 6 weeks. His lawyer had assured me there was no trust. My older brother had already sold the house, closed the estate sale, and told me our father had left barely enough to cover his medical bills. So why had Dad hidden a bank key inside a suitcase? Who was the woman in the photograph? And how could more than $2 million vanish from an estate that, according to every document I had been shown, had never owned it? The stranger looked past me toward the quiet street. "Before I tell you what else I found," he said, "you need to decide whether you trust the man handling your father's estate." Good day, dear listeners. It's Nora again. I'm glad you're here with me. Please subscribe to my channel and like this video. And also let me know in the comments which city you're listening from. That way I can see how far my story has traveled. My name is Lena Bennett. I was 47 years old when my father died, and I lived in Dayton, Ohio, in a small brick house with a narrow porch and a maple tree that dropped too many leaves every October. I had been a hospital billing analyst for almost 19 years. People usually imagined that meant I spent my days sending invoices. In truth, most of my work involved finding the reason 2 versions of the same event did not agree. A physician's notes might say one thing, an insurer's code another, and a patient's statement something else entirely. My job was to follow the trail without assuming that the loudest version was the true one. Numbers are rarely dramatic by themselves. They become dramatic when someone wants you not to look at them. My husband, Paul, had died of pancreatic cancer 4 years earlier. Grief had reduced our life together to a set of final records, medication schedules, insurance forms, a death certificate, the last utility bill with his name still printed beside mine. For a long time, I hated paperwork because it seemed indecent that a human life could end and leave so many boxes waiting to be checked. Eventually, paperwork became a kind of shelter. It did not heal me, but it gave grief edges. It gave each impossible day a task. My father, Harold Mercer, understood that about me. He had worked in bank operations before retiring, and he believed records were a form of memory. "People revise the past," he once told me. "Paper is less talented at lying." Dad was 78 when a stroke took him. He had lived alone since my mother's death 12 years earlier, in the modest 2-story house where my brother Daniel and I had grown up. He polished his shoes every Sunday, used the same steel thermos for 30 years, and kept canceled checks long after the law required it. Nothing about him suggested secret wealth. Daniel was 5 years older than I was. He owned a commercial real estate brokerage in Cincinnati and spoke the language of confidence with such fluency that people often mistook it for competence. He loved Dad in his way, but he also resented him. Dad had refused to invest in 2 of Daniel's developments, both of which later failed. Daniel never openly blamed him. He simply began telling stories in which Dad was cautious, old-fashioned, and incapable of understanding opportunity. After Dad's first minor stroke, Daniel took charge quickly. He arranged home care, hired a lawn service, and had Dad sign a durable power of attorney. I was grateful at first. I was working full-time and still learning how to live alone. Daniel had employees, assistants, and a car that seemed permanently pointed toward the next emergency. When he said, "I'll handle the administrative side," I let him. That was my first mistake. The lawyer handling Dad's affairs was Martin Vale, a polished man in his mid-50s, whose downtown office smelled of leather and expensive coffee. Martin had represented several of Daniel's clients. He wore pale ties, remembered everyone's spouse, and had a way of lowering his voice when he wanted ordinary information to sound confidential. At the reading of Dad's will, Martin placed 3 folders on a glass conference table. Dad's house and remaining personal property were to be divided equally between Daniel and me. After medical debts, home care expenses, taxes, and the mortgage Daniel said Dad had taken out for repairs, Martin estimated that each of us might receive about $32,000. I was surprised there was a mortgage. Dad had celebrated paying off the house when I was in college. Daniel answered before I could ask. The roof, the foundation, the nursing care, he said. Things added up. Martin gave me a sympathetic smile. Longevity is expensive, Miss Bennett. I signed an acknowledgement that I had received a copy of the will. I did not sign a waiver of accounting, although Martin slid one toward me. Routine, he said. Then there's no harm in letting me read it at home. His smile remained, but something behind it tightened. 2 days later, Daniel called and said an estate sale company could clear the house that weekend. I asked for time to sort through Dad's personal things. There's nothing valuable, he replied. You took Mom's recipe box. I kept Dad's watch. We can't become sentimental about every lamp. I went to the house Thursday evening. Several rooms were already marked with colored stickers. The dining table where Dad helped me with algebra had a yellow price tag on it. His winter coat cost $12. A box of family photographs sat beneath a folding table marked free. I remember kneeling on the carpet, putting photographs into my handbag, and feeling that grief had become a clearance event. Daniel arrived while I was in Dad's bedroom. He stood in the doorway with his phone in one hand. You can't keep everything, Lena. I'm not trying to. Then don't make this harder. There was an old brown suitcase on the closet shelf. Dad had carried it on every family vacation until the zipper began sticking. I reached for it, but Daniel said the sale company had already inventoried the room. It's an $18 suitcase, I told him. Then buy it Saturday. He smiled as if he were joking. I thought he was being insensitive. I did not yet understand that he was afraid. That Saturday, I arrived late because of a billing system outage at the hospital. The suitcase was gone. Daniel was standing in the driveway speaking with Martin Vale. Their conversation stopped when I approached. Martin had no obvious reason to attend an estate sale. He said he happened to be nearby. That was the first entry I made in a small black notebook after the stranger came to my door. Martin Vale, present at estate sale, 11:35 a.m. Conversation with Daniel ended when I approached. The stranger's name was Elias Price. He had repaired luggage and leather goods for 41 years before closing his shop. He bought Dad's suitcase because the brass corners were unusually well made. At his workbench, while trying to fix the warped base, he noticed that the interior depth did not match the exterior measurement. A hospital billing analyst notices when totals disagree. A luggage repairman notices when inches do. Elias loosened 4 upholstery tacks and lifted the false bottom. He found the bank key, the photograph, the trust inventory, and a small digital voice recorder. The recorder's battery was dead. There was also an empty document envelope with a red wax pencil mark across the flap. On the front, Dad had written, "Original certificates, 2 million zis." Elias did not know whether that meant cash, bonds, certificates of deposit, or something else. He only knew that the envelope had been slit open and emptied. "Did you remove anything?" I asked. He did not look offended. He seemed relieved that I asked directly. "No, and you shouldn't rely on my word. My building has a security camera over the workbench. It recorded me opening the case." That answer changed the way I saw him. Honest people do not always have proof, but dishonest people rarely offer it before they are accused. He gave me a copy of the footage on a flash drive. It showed him placing the closed suitcase on a green work mat, measuring it, removing the tacks, and discovering each item. The envelope was already empty. I asked why he had returned everything instead of calling the estate sale company. "Because I called the number on the receipt," he said. "A man named Daniel told me to burn the papers and name my price." For several seconds, I could hear only the rain falling through the maple leaves. "What exactly did he say?" Elias reached into his coat and handed me 2 pages. He had written down the time of the call, the number, and the conversation immediately afterward. He had also saved a voicemail. Daniel left 20 minutes later. Mr. Price, this is a private family matter. Destroy what you found. I can compensate you generously, but continued interference may expose you to liability for possession of stolen financial records. Daniel's voice was calm, almost friendly. I had heard that tone before. It was the tone he used when he wanted another person to mistake pressure for help. Elias left the suitcase with me, but he kept the original camera footage and his notes. That was my suggestion. If someone came into my house, I did not want every piece of evidence in one place. After he drove away, I locked the door and put the suitcase on my kitchen table. The key was stamped 317 and bore the name Miami Valley Heritage Bank, an institution that had merged twice and no longer operated under that name. The inventory page was dated 11 months before Dad's death. It listed a Mercer Family Preservation Trust, 2 Treasury securities, a money market account, and a small portfolio of municipal bonds. Total value, $283,417.26. Beside each item was a handwritten checkmark, except one line. Successor trustee confirmation, Lena Ann Mercer Bennett. There was no checkmark beside my name. The photograph showed Dad about 15 years younger, standing outside a red brick bank branch. The woman beside him appeared to be in her early 60s. On the back, someone had written, Harold and Miriam. After the hearing, I searched for Miriam in Dad's address books and found only one. Miriam Cole, with an old Indiana number. The voice recorder needed an obsolete charging cable. I found one online but did not connect the recorder to my computer. At work, malicious files sometimes arrived disguised as medical records. Grief did not exempt me from basic caution. That evening, Daniel called. A strange man contacted me about Dad's luggage, he said. I looked at the suitcase under the kitchen light. Did he? He may try to scam you. Dad was confused near the end. What kind of scam? Claims about hidden money, forged records. You know the type. Daniel did not ask whether Elias had contacted me. He already knew. Did Dad have a trust? I asked. There was a pause, no longer than a breath, but I heard it. Not when he died. That was not the same as no. Martin said there was no trust. Then there was no trust. Those are different answers. His voice softened. Lena, I know the last few years have been lonely for you. People can take advantage when someone wants a mystery to mean more than it does. He had turned my widowhood into evidence against my judgment. Send the suitcase man to Martin, he continued. Let the professionals handle it. I'll think about that. After we hung up, I wrote down the conversation as precisely as I could remember it. Then I photographed every object from the compartment beside that day's newspaper. I placed the originals in separate, tamper-evident envelopes left over from an audit project at work, signed across the seals, and stored them in a safe deposit box at my own bank. I kept copies in 2 locations. I changed my email password, enabled 2-factor authentication, and checked the doors twice. I was frightened, but fear is not always an instruction to run. Sometimes it is a request to slow down. At 1 a.m, I sat at the kitchen table with Paul's old mug between my hands and made 3 columns in my notebook: what I knew, what I had been told, what I could prove. The first column was small, the second was crowded, the third held only the suitcase footage, Daniel's voicemail, the inventory, and the key. It was enough to begin. The next morning, I called Priya Shah, an attorney whose daughter had once been treated at our hospital. Years earlier, I had corrected a coding error that saved her family months of insurance appeals. We were not close friends, but I knew she handled probate litigation and fiduciary fraud. I told her only that I had found documents suggesting an undisclosed trust connected to my father's estate. Who is the estate lawyer? She asked. Martin Vale. Silence. Do not call him, she said. Do not call your brother. Bring me everything. Priya's office was above a bookstore, with mismatched chairs and case files stacked in disciplined towers. Unlike Martin, she did not make uncertainty sound reassuring. She made it specific. She examined the inventory through a clear evidence sleeve. This may be a private record, she said. It may be outdated. The assets may have been lawfully spent or transferred. But if a trust existed, and you were named successor trustee or beneficiary, its disappearance from the probate discussion is significant. Can $2 million just disappear? Not cleanly. That was the first comfort I felt. Priya asked Elias to deliver the original video file. and sign an affidavit when describing discovery. She had a digital forensics consultant preserve the file's metadata. She sent formal litigation hold letters to Daniel, Martin, the estate sale company, and the financial institutions named in the inventory. The letters required them to preserve emails, texts, account records, surveillance footage, and documents relating to Dad's estate and trust. She also filed a petition in probate court demanding a full inventory and accounting, and asking that no estate assets be distributed until the discrepancy was resolved. "Will Daniel know?" I asked. "By tomorrow. Then we have today." For the first time, Priya smiled. We spent that day building a chronology. Dad established the Mercer Family Preservation Trust 9 years earlier, according to a notarized reference on the inventory. 3 years later, he amended it. 4 years after that, shortly after his first minor stroke, he granted Daniel power of attorney. 11 months before Dad's death, the trust still held more than $2 million. 6 months before his death, title to his house was transferred out of the trust and back into his individual name. 4 months before his death, a mortgage appeared. Every unusual event occurred after Daniel took control. The bank key led us to a surviving branch of the institution that had acquired Miami Valley Heritage Bank. Priya obtained a temporary court order allowing the box to be secured but not yet opened. Box 317 was registered jointly to Dad and the trust. Access records showed 3 visits in the previous year. Dad had entered once. Martin Vale had entered twice. The most recent visit was 9 days after Dad's stroke left him unable to speak. Martin's authorization was based on a trustee certificate naming him as co-trustee. Priya checked the county records, Dad's papers, and the documents Martin had filed in probate. No such certificate appeared anywhere else. 2 days after our petition was served, Martin called me. His tone was warm. "Lena, I'm concerned there's been a misunderstanding. Priya asked that communications go through her." "Of course. I'm calling as an old friend of your father, not as counsel." "You weren't his friend." He let the silence sit between us, then gave a gentle laugh. "Harold trusted me with matters you may not have understood. Your brother protected him from considerable financial instability. If you force private medical information into public court records, you may damage your father's dignity." It was an elegant threat. "Withdraw the petition, or we will portray Dad as incompetent." "Please send anything relevant to my lawyer," I said. "Litigation can consume an estate. Whatever you think exists may vanish into legal fees. Then a complete accounting should save us all time." His warmth disappeared for half a second. "Your husband handled difficult things for you, didn't he?" I felt the remark land exactly where he intended. "Goodbye, Mr. Vale." I ended the call and emailed Priya a summary. My phone log preserved the time and duration. Ohio law permits a person to record a conversation to which she is a party, but Priya had told me not to improvise. From then on, every call from Martin or Daniel went to voicemail. Pressure arrived in polite packages. Daniel emailed that my petition was delaying payment to Dad's caregivers. Martin sent a proposed family resolution offering me $75,000 if I released all claims, consented to the accounting as filed, and agreed not to discuss Dad's finances. The offer contained a sentence saying it was made solely to protect me from emotional distress. Priya circled that line. People rarely pay $75,000 to protect someone from a non-existent trust. At home, an anonymous envelope appeared in my mailbox, containing a photocopy of one page from Dad's medical chart. The page mentioned mild cognitive impairment. Someone had highlighted the phrase impaired judgment. At work, my supervisor received a complaint alleging that I had searched Dad's hospital records without authorization. I had not. An audit confirmed that within a day, but the allegation frightened me more than the calls. My livelihood was ordinary, careful, and essential. Someone knew that attacking my reputation could do what threatening my body could not. I gave Priya the envelope. The postmark came from Cincinnati, where Daniel lived and Martin worked. "Can we prove who sent it?" I asked. "Not yet." Those 2 words became a discipline. Not yet did not mean never. It meant do not claim more than the evidence can carry. The court granted our request for an independent temporary fiduciary and ordered Martin to produce trust documents within 10 days. He responded that the trust had been substantially exhausted for Harold Mercer's benefit and that several original documents could not be located. He produced 1,842 pages. Most people imagine concealment means withholding paper. Professionals often conceal by supplying too much of it. Priya, a forensic accountant named Simone Barrett, and I divided the records. My hospital work had trained me to compare dates, codes, and authorizations. Simone tracked transfers. Priya mapped legal duties. On page 1317, I found a photocopy of a wire request for $480,000 to Riverbend Development Holdings. Daniel owned 40% of Riverbend. The stated purpose was secured income-producing investment for settler care. There was no security agreement attached, no appraisal, and no interest payment listed afterward. Another $625,000 had gone to a company called Northline Consulting. Its mailing address was a suite in Cincinnati. The suite number matched Martin Vale's former office. 3 payments totaling $310,000 were labeled home renovation. The contractor's invoices described structural repairs, but the estate sale photographs showed the same kitchen cabinets, the same roof, and the same cracked tile I remembered from the previous Christmas. Simone found the pattern. Money had moved from the trust to a holding account, then through businesses connected to Daniel and Martin. Smaller amounts returned as loan proceeds to Dad's personal checking account, creating the appearance that he had borrowed money for care. The mortgage on his fully paid house was then used to cover expenses that should have been paid directly by the trust. They had not merely stolen his money, they had made him look indebted to the people stealing it. I sat in Priya's conference room staring at the flowchart. In billing, a false code can travel through a system until it becomes an invoice, a denial, a collection notice, and finally a frightened patient who assumes the system must be right. Daniel and Martin had done the same thing to Dad's life. They entered a false premise at the beginning and allowed every later for record to repeat it. How much can we trace? I asked. 1.6 million so far, Simone said. The rest may be in the box records or the missing certificates. The court ordered box 317 opened in the presence of both parties. The vault room was smaller than I expected. Fluorescent lights reflected on pale stone walls. A bank officer placed the long metal box on a table. Daniel stood beside Martin across from us. He would not look at me. Inside the box were copies of Dad's original trust, an amendment naming me successor trustee, tax returns, and a sealed letter addressed to me. The original treasury certificates were gone. The access log showed Martin had entered the box on March 14. A withdrawal confirmation inside the bank's archived system showed that 2 treasury notes with a combined redemption value of $1,038,000 had been transferred to a brokerage account that same afternoon. The receiving account belonged to a trust with a nearly identical name, Mercer Family Preservation Trust II. The original was Mercer Family Preservation Trust. One Roman numeral had redirected more than $1 million. The second trust had been created by Martin. Daniel was its sole beneficiary. Martin objected that the documents were confidential attorney work product. Priya replied that financial instruments removed from a client's box were not legal advice. The bank officer stopped the meeting and notified internal security. Dad's sealed letter was only 3 pages. The handwriting became shakier toward the end. Lena, if you are reading this, I waited too long to admit I made a mistake. Daniel asked for help after Riverbend failed. I agreed to lend him $200,000 if proper papers were prepared. Martin brought documents to the house. The copies I later received were not the papers I remember signing. Dad wrote that Miriam Cole had been his supervisor years earlier and later became a volunteer court advocate for older adults. He called her after noticing unusual tax forms. Miriam helped him review the trust. They discovered that Martin had inserted a co-trustee certificate and that Daniel had taken far more than the authorized loan. Dad hid copies because he was ashamed. He planned to remove Daniel's power of attorney and report Martin to the disciplinary board. Before he could complete the process, he suffered the major stroke. At the bottom of the last page, he wrote, "I was afraid that exposing your brother would destroy our family." Silence did not save it. It only gave dishonesty more time. I read that sentence twice, then placed the letter on the table. Daniel finally looked at me. You don't know what Dad promised me, then produce the agreement. He wanted the business to survive, then produce the agreement. He turned to Martin, but Martin was already packing his papers. That was the moment I understood their partnership had limits. Manipulative people can look united while the secret is safe. Evidence makes them calculate separately. The bank froze the receiving brokerage account. Only $412,000 remained. The rest had moved again. Our civil complaint alleged breach of fiduciary duty, conversion, fraudulent transfer, elder financial exploitation, and civil conspiracy. Priya also referred the evidence to the county prosecutor, the state securities regulator, and the disciplinary council responsible for attorney misconduct. The criminal investigation would take time. The civil case gave us tools immediately. Subpoenas, depositions, sworn answers, and access to records neither Daniel nor Martin wanted examined. Then Daniel came to my house. It was almost 8 in the evening. He stood on the porch without an umbrella, his hair wet, his expensive coat darkened by rain. 5 minutes, he said. I did not invite him inside. Priya had told me never to meet him alone, so I called my neighbor Ruth and left my phone connected on the hall table where she could listen. My doorbell camera recorded the porch. Daniel noticed the blue light. You're recording your own brother? You offered a stranger money to burn Dad's records. He looked toward the street. Martin told me those papers were invalid. You knew enough to want them destroyed. His face softened into the expression he had used at Paul's funeral. I was trying to keep us out of a scandal. Dad loaned me money. The developments failed. Martin moved things around to buy time. You mortgaged Dad's house. Temporary liquidity. You sent false invoices. That was Martin's structure. You filed a complaint against me at work. He did not answer. There are silences that contain uncertainty. His contained confirmation. Daniel stepped closer to the door. There's still a way to resolve this privately. I can sign over my share of what's left. You withdraw the fraud allegations, and Martin handles the tax cleanup. Martin will never handle another document for me. You'll send me to prison over money you didn't even know existed? That question hurt more than I expected, not because it was persuasive, but because it revealed what my brother believed the case was about. No, I said, you may go to prison because you exploited a sick man who trusted you. The money is how the records remember it. His mouth tightened. Dad always thought you were the responsible one. Tonight I am. I closed the door. The deposition took place 4 months later in Priya's office. By then, the court had removed Martin from every role in the estate and appointed a retired judge as special master. The state bar had suspended Martin on an emergency basis. Daniel still presented himself as a businessman trapped by complicated documents. Under oath, he testified that Dad had authorized every transfer. Priya asked whether the authorization was written. Daniel said it was oral. She asked why the wire forms described secured investments. He said Martin chose the language. She asked what collateral Riverbend had provided. He said he did not recall. She asked whether he had told Elias Price to destroy documents. Daniel said no. Priya played the voicemail. He leaned toward his attorney and whispered for almost a minute. Then he said the message had been taken out of context. What context makes destroy what you found refer to something other than destruction? Priya asked. His lawyer objected. Daniel did not answer. Martin's deposition was colder. He admitted entering the safe deposit box, but claimed Dad instructed him to do so. He admitted creating the second trust, but described it as an estate planning convenience. He said the Roman numeral was used to distinguish an amended vehicle. Priya placed the 2 trust documents side by side. The original trust required 2 independent witnesses for any change of beneficiary after Dad reached 75. The second trust had 1 witness, Martin's paralegal. The paralegal, Celeste Warren, had already testified. She said Martin asked her to sign a witness page without Dad present. Martin claimed she was mistaken. Priya then showed him the building access records from his office. Celeste's badge had entered at 8:12 on the morning she signed. Dad was hospitalized 11 miles away. Hospital visitor records showed Martin had not visited that day. Martin's expression did not change, but his right hand stopped moving. Are you asking this tribunal to believe, Priya said, that Harold Mercer executed a trust amendment in a hospital room you never entered? witnessed by an employee who remained in your office. His lawyer instructed him not to answer on the ground that a criminal investigation was pending. That refusal did not prove guilt by itself, but it ended the illusion that this was a family misunderstanding. The largest breakthrough came from Miriam Cole. We found her in Bloomington, Indiana. She was 76 and living in a small retirement community. She remembered Dad clearly. Miriam had kept a copy of a recorded video call with him, made 2 weeks before his major stroke. Dad appeared tired but alert. He stated his name, date, location, the nature of his assets, and his intention to remove Daniel and Martin from positions of control. He held his driver's license to the camera and read the first page of the original trust aloud. More importantly, he described a meeting at his house at which Martin asked him to sign what Martin called a loan authorization. Dad later saw a title page on Martin's desk reading Mercer Family Preservation Trust 2. "I never created a second trust," Dad said on the recording. "I never gave Daniel my daughter's share. If documents say I did, those documents are false." Miriam had urged him to contact police immediately. Dad asked for 1 week to speak with Daniel. He suffered the stroke 4 days later. The medical experts eventually agreed the stroke resulted from long-standing vascular disease. There was no evidence anyone caused it. The timing was terrible but not criminal. Priya insisted we separate suspicion from proof, even when the separations disappointed me. That insistence made everything else stronger. The civil hearing lasted 6 days. The courtroom was not dramatic in the way television courts are. There were long periods of page numbers, foundation questions, objections, and bank employees explaining systems designed to sound boring. But truth often arrives through boring doors. Simone traced $1,671,400 in unauthorized transfers. Of that amount, $412,000 remained frozen. Daniel had used $386,000 to cover debts from Riverbend projects, $214,000 as a down payment on a condominium, and $119,000 to pay personal and business taxes. Martin's firm had received $287,000 through Northline Consulting. Other funds had passed through accounts belonging to 2 investors, both of whom agreed to return the money after subpoenas showed they had received trust assets disguised as project refunds. The missing treasury proceeds were traced through the second trust into a brokerage line of credit. Martin had pledged them as collateral. When the market declined, part of the position was liquidated. For 3 hours, a bank compliance officer explained access logs, authorization codes, and time-stamped scans. The key from the suitcase matched box 3710. The transfer confirmation matched Martin's vault visit. The certificate numbers matched Dad's inventory. The suitcase was no longer an old object with a hidden compartment. It had become a chain, connecting each disputed fact. Daniel's lawyer argued that Dad had always intended to treat both children differently because Daniel had helped with his care. Priya showed payroll records proving that Dad had paid professional caregivers, while Daniel's visits averaged less than twice a month. Martin's lawyer argued that the second trust corrected a drafting error. Priya showed billing entries from Martin's own system. One read, DM restructuring, asset isolation prior to HM, incapacity review. Another read, prepare alternate certificate, avoid beneficiary notice until funding complete. Martin said the abbreviations could refer to other clients. His office's matter number referred to Harold Mercer. Then Elias testified. He wore the same brown jacket he had worn on my porch. He described buying the suitcase, noticing the false bottom, and calling the estate sale number. The courtroom watched the security video. No one spoke as his hands lifted the lining and revealed Dad's hidden records for the first time. Priya played Daniel's voicemail. Elias was asked whether I had promised him money. "No," he said. "Did Ms. Bennett ask you to alter your account?" "No." "Why did you get involved?" He looked at the judge before answering. "Because someone spent a lot of effort making the truth look like trash." The judge's written ruling came 3 weeks later. She found that Daniel and Martin had exercised undue influence, breached fiduciary duties, converted trust assets, submitted false instruments, and concealed material facts from both the probate court and me. The second trust was declared void from its creation. The house transfer and mortgage were unwound to the extent legally possible. Constructive trusts were imposed on Daniel's condominium, Riverbend distributions, Martin's consulting payments, and several traced accounts. The court awarded compensatory damages, statutory enhanced damages under Ohio's elder abuse provisions, attorney fees, and costs. The total civil judgment exceeded the amount originally missing because fraud has consequences beyond repayment. Not all of it could be collected at once. Justice is an enforceable judgment, not a magician's hand. Over the following year, the special master recovered approximately $1.74 million through frozen accounts, asset sales, insurance coverage, and negotiated returns from third parties. The mortgage lien against Dad's house was released. After taxes, fees, and administration, the restored trust held a little more than $1.5 million. The criminal cases resolved separately. Martin pleaded guilty to theft from an elderly person, tampering with records, and money laundering. He surrendered his law license and received a prison sentence followed by restitution obligations. Daniel pleaded guilty to complicity in theft and attempted evidence tampering. His sentence included incarceration, community control afterward, and restitution. The prosecutor considered his cooperation in locating additional assets, but the court rejected his request for probation only. I attended the sentencing and did not speak. Daniel looked smaller than I remembered. For a moment, I saw the boy who used to carry my school bag when older children teased me. Then I saw the man who had used our father's illness, my husband's death, and my professional reputation as tools. Both were real. Loving who someone once was does not require surrendering to what he became. After the hearing, Martin's former paralegal approached me. Celeste apologized for signing the witness page. She had been afraid of losing her job, then afraid of admitting what she had done. I kept telling myself it was only a signature, she said. A signature is small, I replied. What it authorizes may not be. She nodded and began to cry. I did not comfort her as if nothing had happened. I also did not punish her beyond what the process had already required. Accountability and cruelty are not the same thing. The house was returned to the trust, but I did not move into it. For months, I thought saving Dad's house would feel like saving Dad. When I finally stood alone in his bedroom, I understood that a building can hold memory without being asked to hold your future. I kept the family photographs, his steel thermos, my mother's sewing basket, and the old suitcase. The house was sold to a young couple with 2 children. They asked whether they could keep the marks on the pantry door, where Daniel's and my heights had been recorded in pencil. I said yes. With my share of the trust, I paid off the mortgage on my small brick home. I replaced the leaking porch roof and built narrow shelves in the spare room. I did not quit my job. I reduced my hours to 4 days a week and began volunteering with a nonprofit that helps older people and their families understand medical bills, powers of attorney, and financial warning signs. We named one of the workshops the Quiet Audit. Elias attended the first session. He refused every reward I offered beyond reimbursement for his travel and lost work. Eventually, he agreed to let the nonprofit purchase tools for an apprentice program at the community workshop, where he taught leather repair. "That isn't for me," he said. "Exactly," I told him. Miriam and I became friends by telephone. Once a month, we spoke for an hour. She told me stories about Dad as a young bank employee, how he once stayed until midnight to find a 7-cent imbalance, how he kept peppermints in his desk, how he was braver with other people's problems than with his own. That last part made me sad because it was true. I used a modest portion of the inheritance to travel to places Paul and I had postponed seeing. I went to Nova Scotia in September and watched fog lift from the harbor. I visited Santa Fe and bought one blue ceramic bowl. I came home each time grateful to leave and grateful to return. In the spring, I planted lavender beside the porch and tomatoes along the back fence. Dad had never trusted tomatoes from a grocery store. The first year, squirrels ate nearly half of them. I laughed harder than the situation deserved. Peace, I learned, is not the absence of a complicated past. It is the moment the past stops controlling every room you enter. Daniel wrote to me from prison twice. The first letter explained. The second apologized. I answered only the second. I told him I hoped he would use his remaining life honestly. I told him forgiveness, if it came, would not erase restitution or restore access to my finances. I told him boundaries were not revenge. He wrote back that he understood. I do not know whether he did. The suitcase now sits on the bottom shelf of my study. I had Elias repair the lining, but I asked him to leave the hidden compartment intact. Inside it, I keep copies of the court's judgment, Dad's letter, and the photograph of Dad with Miriam. There was never $2 million in cash inside that case. That was what Daniel's attorney tried to emphasize, as if the title on an envelope made the entire discovery less real. But the suitcase carried something money could not replace: a map of where the truth had been buried. The stranger who bought it did not return $2 million to me. He returned the chance to ask why it was missing, and that question changed everything. For years, I had believed being a good daughter meant keeping peace, accepting explanations, and trusting the family member who sounded most certain. I know now that peace built on silence is only delayed damage. If a record does not balance, do not let affection force the numbers to agree. If someone pressures you to act before you can read, slow down. Keep copies, ask precise questions. Seek advice from someone whose loyalty is to the truth, not to the family story. And remember that calm is not weakness. Sometimes calm is how courage organizes itself. Money did not give me a new life. Truth gave me ownership of the life I already had. Justice gave Dad's final wishes a voice. Healing taught me that I could miss my brother, mourn my father, protect myself, and move forward without pretending any one of those feelings canceled the others. So let me ask you, if a stranger returned something your family had thrown away, and it revealed that the person you trusted most had hidden an entire inheritance, what would you have done?